The Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference. Realities for a New Reality. 2 days, 25 workshops, renowned speakers and presenters, by families, for families, nearly 40 hours of unfiltered and straightforward information, made possible by the leaders in disability rights advocacy for over 45 years, Hinkle, Pryor, and Fisher, attorneys at law. So welcome to this session of our ongoing encore presentation series of the Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference.
Welcome everyone, and good morning for Saturday, October 3rd, 2020 and welcome to the Hinkle, Pryor, and Fisher Virtual Parent Empowerment Conference. I'm Paul Pryor, and I am your moderator and host for today for this workshop entitled Securing Your Future for Your Child with Special Needs, Financial and Estate Planning, presented by Don Brown.
Good morning.
Before we get into the presentation, a couple, just housekeeping rules. Before we begin, we ask all participants to mute their microphones throughout the session. This workshop is scheduled to last for approximately 90 minutes. And if time allows, Don will be taking questions at various points through the presentation at the end. Please ask your questions through the chat feature, if you would, in the control bar. I will be collecting and shoveling the questions Don's way, again, time permitting. And it's now my pleasure to welcome and present Don Brown. Don has been in the financial and service industry since 1985. He started when he was about 10, by the way.
Exactly.
During his distinguished career, he has been recognized as an industry leader in both personal production and management and client management and so forth. Educating individuals with families on how to properly plan for a dependent with special needs is Don's primary focus. He regularly presents at local support groups and nonprofit organizations, including a monthly educational workshop for expecting parents on the basics of financial security. And Don is presented at a number of state and national conferences on the topic. Don also provides assistance to local businesses. He is active in his local Chamber of Commerce, who has previously recognized him as their Member of the Year, and he is a current member of their Board of Directors. In addition, he runs employee workshops on topics including retirement planning to corporate clients. Don has demonstrated a broad and long-standing commitment to local community and philanthropic service, and I do know that to be true. He is an over 25-year volunteer with Camp Fatima of New Jersey, an all-volunteer camp, a 101 camp for children with developmental challenges. He annually acts as a camp activity staff member as well as serves on their finance committee. Don is a graduate of Rutgers University, go the Scarlet Knights, with a degree in economics and finance, and holds a series, this is what I always love the best, holds a series 6, 7, 63, and 24 security registrations. Well, I think a football should have been hiked there. Along with his life, annuity, accident, and health licenses, and he holds a number of financial planning certifications and designations. So, Don, welcome. Thank you for being here. Take it away.
Thank you. Good morning, Paul. Thank you for my obituary while I'm still here on Earth. Good morning, everybody. Welcome aboard. Thank you for sharing your Saturday morning. I would be remiss if I didn't first thank the Hinkle, Pryor, and Fisher firm for putting together an absolutely terrific conference. As much as I do, the Hinkle firm, as people for supporters of the special needs community, just do a great, grand, and terrific job. I'll put out a couple housekeeping notes of my own along the way. You'll notice in the chat, I've entered a connection. What we will be doing is, if anyone would like a consultation, whether you know you want one now or by the end of our meeting, you can click right on that smart sheet, enter your information, including questions, and we'll contact you. If you have questions during the workshop, please feel free to put them in the chat. and we will address them as we go. Two things you'll recognize. One, I'm not the greatest looking guy. Two, I don't have the greatest voice, so you know the content in our meeting better be good. So we give you 3 commitments during every workshop that we do, and we'll get started right away. Commitment number 1 is obviously you're here to learn something. So we want to give you things that are educational, information that you don't have to look and fight for, and that's usable, which leads to step number 2. We want you to walk away from this workshop with at least one actionable item where you say to yourself, glad I was on that workshop. And at the very least, we'd also like it to be entertaining. So you want to ask questions along the way, you can do that. We can also do that at the end, whatever way you are comfortable, we're happy to do that. So without any further ado, let me share our screen and we'll get started. Okay. There. Okay, there's our disclosure. So today what we're going to be doing is we're going to be presenting to you strategies that will help make the future of your dependent with special needs more secure. Paul, can everyone see the screen? Just want to make sure.
Yep, absolutely.
Perfect. Okay.
Good looking screen too.
Here's the idea behind this. We know that particularly during the early years and then in transition for your son, daughter, or dependent with special needs, you have to fight for everything. You have to fight for IEPs. You have to fight for health insurance. You have to fight for benefits and services. The idea of this workshop is to give you a step-by-step process where you don't have to look and fight for things. It's almost like a checklist of the things that you should be doing if you have a dependent with special needs. Some of these things you may have addressed already. Some of these things may be new to you, but the idea is to give you a process without you having to create one yourself. So what we're going to do is we're going to present 10 steps for every family that has a special needs dependent. Again, if you have questions along the way, please put them in the chat. If you want to sign up for the consultation, you'll see the smart sheet, and everyone that signs up or sends us an email will receive a kit from us that includes the 10-step summary, a special needs planning quiz, and some of the other resources that we share with our community. So let's go. Okay, so first thing, what is the most important thing to you as a caregiver? So whether you're a parent, whether you're a guardian, as a caregiver of a dependent with special needs, you're the one that's looking out for their best interests. You're their best advocate. So we also know that one of the big questions that you'll have somewhere along the way, and probably it's 2 a.m. in the morning when you can't sleep, is what happens when you're no longer there? Well, who's going to be able to take care of that person for you in the best way possible, the way that you would want to? And this whole workshop is designed to help you plan to get that to happen for you. Okay, not. There we go. Okay, so step 1 says plan for the future, which is obvious. But what we want to point out to you is hoping is not a plan. Hoping that your siblings will step in, hoping that your special needs dependent siblings will step in. That's not a plan. That's just a hope. So when we're talking about creating a plan, we want to talk about creating a plan that's going to take into account all of the things that are most important to you. The medical treatments or any treatments that you have for your special needs dependent. What is their education going to be like? After they get out of primary school, are they going to go to vocational school? Are they going to go to one of those college programs now that are geared towards special needs dependent? Will they go directly to a work program? All of those things, the more we know in advance, the better we can plan for them. In addition to that, where will my special needs dependent live? Are they going to continue to live at home with you? Are they going to be as independent as they could possibly be and be in a setting that is either a group home, an individual home, or something that allows them to have a quality of life and an independence that you would want for them? All of these things are combined in what's called a life care plan. Yesterday during the Guardianship program, Alan from Plan New Jersey talked about having a life care plan, knowing what's going to happen to your special needs dependent when you're no longer there. The steps that we're going to go through will give you a step-by-step process of what to include in that plan. So, step 2 is review beneficiaries. But before I do that, I want to point out probably one of the most important things when it comes to government benefits for our families. Those of you that are on the meeting that have dependents or children that are in what's known as the transition phase, which is the ages between 15 and 21, this is the first time you may come face to face with this if no one's taught you. But we know in New Jersey, as an example, the services that are delivered to anyone between the ages of 3 and 21 are typically done through the Department of Education. They are your right. When an individual turns age 21, however, the services that are going to be delivered to an individual with special needs as an adult are typically delivered through Medicaid, which becomes the first major planning hurdle for all of our families. The reason is very, very important. In order for an individual to qualify for Medicaid, they typically can have no more than $2,000 of assets in their name. So think about this challenge for a minute. It's a catch-22. We want our special needs dependent to have as much education as possible, to have an independent life, to have a quality of life. But in order to do that, we need government support services to make that happen. And if we can't have more than $2,000 of assets in our name, in order to get those support services, there's our first catch-22. So in our planning, we're going to talk about how to position assets both for the individual in their name and for the individual's use not in their name. And we're going to talk about 3 specific things today. The first thing we'll mention is an ABLE account. We have a workshop that we'll do sometime in the future that just addresses the ABLE account. But if you're not familiar with the ABLE account, it's very much like a 529 plan, if you're familiar with education plans. And what it does is it allows an individual with special needs to have a tax-free savings account where they can deposit up to $15,000 per year into that account and still qualify for government support services. You are allowed to accumulate up to $100,000 in that account before any government benefits like SSI would be affected. What we teach people is that account should not be an accumulator of assets. That account should be the first line of where we're depositing monies and using monies for your special needs use, for your special needs dependent. But the reason we bring this up so early in our presentation is most of our families and clients either don't realize this, or if they realize this, they make unintended mistakes. The first biggest mistake that our families make, and the first takeaway that I want you to have for today, is I want you to go back and I want you to review the beneficiaries of all of your benefits. The benefits that you have through work, your group life insurance, the benefits you have through work in the form of your retirement plans. Most of us, when we're filling out those forms, we add a primary beneficiary. And many times on those forms, there's a little box you check off that says, make all of the children of our marriage our contingent beneficiary. We need to make sure that your dependent with special needs is not an unintended or an intended beneficiary of any of your benefits. What I want to do is I want you to envision something for a minute that's very, very important. If we're talking about your special needs dependent being a beneficiary of your group life insurance, your individual life insurance, or any of your benefits, what that means is they are now receiving money, and they're receiving money because you're no longer here. And if as a result of receiving those monies, they are now removed from any of the government support services that they may be currently involved in, that becomes a major problem. And what we always teach our families is when these types of problems arise, there are only 2 things that solve them. Those 2 things, if you think about it, are time and money. And if you're not there to control those 2 things, it becomes an even greater compounded problem. So your first takeaway is to make sure that your special needs dependent is not a direct beneficiary of any of your benefits. And that includes both inheritances, any assets that you would leave them, things like jewelry, things like cash, things like real estate. None of those things should be going directly to your beneficiary that has special needs. Okay, step 3 is to have a family meeting. What do we mean by a family meeting? We know that when we're raising a dependent with special needs, it's a family process, everyone's involved. But when we're talking and answering the question, what happens when I'm gone? That also means we should have a family meeting to discuss future needs, to discuss any concerns the family has, future care option for your dependent with special needs. Is the individual that you would hope become guardian for your special needs dependent, would care for that special needs dependent? Are they able to do that? Are they willing to do that? Is this something that you can plan for so you know in advance? And discussing everyone's concerns and what those future care options should be also help you plan to make sure that those transitions happen successfully. Okay. Step 4 is create a team. Just by you being on this workshop, we know that you're taking active, positive steps to do those things. And when we're talking about creating a team to have the best possible outcome for your dependent with special needs, we're talking about having a team of people that would include a financial professional that is familiar with the intricacies of special needs planning. To have a special needs attorney like Paul, Maria, and their team to make sure that when you're doing your estate planning, you're doing it in the proper way. Later in our workshop, when we start to talk about special needs trust, it is critical that you have a qualified attorney like Paul, Maria, and their team to make sure that your special needs trust is not only drafted properly, has the proper wording in it, but also would qualify for with the Social Security Administration. What many of our families don't realize is when they pass away and their individual special needs dependent is now going to qualify for additional government services because they're no longer there. When you give your special needs will and trust, a Social Security Administration layperson is the person that's going to decide whether that trust qualifies or not. So we'll talk about that a little bit more, but what I want you to remember is if there's a problem with that trust and you're not there to solve it, the time and money issue gets compounded. Certainly you're going to be dealing with your health professionals, guidance counselors through school, work coaches, all of those things. If you think about putting your special needs dependent in the middle, and then we surround him with all of those professionals, that's where we want to have a coordinated effort, and we're going to have the best possible outcomes. Step 5 is to get additional resource support. Again, I know by you being on this workshop, you're already taking steps to do that. And that additional resource support is through local nonprofit organizations that you may be a part of, through the government agencies that we're going to talk about a little bit in detail, and again, through firms like Hinkle, Pryor, and Fisher that are providing these important workshops, that are providing all of these resources, that are advocates for the special needs and disability community. Getting all of that information and getting access to that information, sharing it with other parents in your groups becomes one of the best ways to communicate important information, and it also gives you one of the best ways to have better outcomes when you're doing your planning. Okay, when we're talking about government agencies, we're going to talk about two things specifically today. We're going to talk about Medicaid, and we're going to talk about Social Security. So Medicaid first, for anyone who has children that are younger or anyone who has special needs dependents that are in that transition phase, which is the ages of 15 to 21, the first thing you must realize is when your child becomes age 21 and they age out of the school system, now any of the government support services that are going to be provided will be provided through Medicaid. Oftentimes they're provided through nonprofit organizations that are funded by Medicaid, but remember it's critical in order to qualify for Medicaid, an individual cannot have more than $2,000 of assets in their name. In addition, Social Security becomes one of the resources that's usable. And what we want to distinguish today is the difference between SSI and SSDI. SSDI is Social Security Disability, which is for you and me based on our work history. If we become disabled, we can collect against Social Security Disability based on our own work history. For an individual that is unable to work and be independent, there is further government support in the form of SSI. It's called Supplemental Social Insurance. When an individual turns age 18, they are now allowed to apply for SSI. They can apply earlier, but the SSI is based on the parents' resources, not the individual's. When that individual becomes a legal adult at the age of 18, now the SSI is based on their own resources. So having the ability to be able to qualify for those two benefits becomes critically important. In the previous workshops that we had earlier in the year in the Hinkle Conference, the head of the New Jersey ARC said the Medicaid and SSI benefits are the lifeline for our special needs dependent in order for them to have a level of independence and quality of life. And when you're looking at those government benefits, it's not only medical treatments, it's supplies, it's equipment, it's financial assistance, it's work program, it's transportation programs, it's group housing supports, all of the things that we would want to make sure we have in place to make sure that our dependent with special needs is going to be able to achieve the quality of life and the independence that we so want them to have, and we work so hard during their childhood to make sure that they can achieve. Step 7 is talking about your estate planning in the form of your last will and testament, and then in the form of a trust. Later today, Paul's going to have a workshop specifically on the estate planning documents. So before we get to that, let me give you a little foreshadowing as to the uniqueness of those documents, the simplicity that you use them for, and what they actually do. So in our workshops, we always get people involved and we ask them questions. And one of the questions we always ask is, can you give me a one-word definition for a will? And people often say different things like contracts, things like that. The word I want you to write down today so you'll never forget it, and when you go over those documents with Paul later, it'll be crystal clear for you. The one-word definition for a will is a note, because that's exactly what a will is. If you were going away for this weekend and you were leaving Paul and I to watch your house or watch your dependent, you'd leave us a note. Here's where we are. Don't call us. Only kidding. But here's the neighbors.
And Don and I would have a giant party. We would trash your place, by the way.
Here's the name of the doctors. Here's the name of the neighbors, etc. Well, a will is your note, and you're never coming back. So a will is going to accomplish 3 things that are important to our planning today. Number 1, it says who gets your stuff. Number 2, who becomes guardian of your dependents. So there's a whole workshop. If you didn't see it yesterday, you can go back and look at it about the importance of guardianship and the different levels of it. But for a special needs dependent, your will should be naming who becomes guardian of your special needs dependent when you're no longer there. The next thing we want to talk about is a special needs trust. And this is where the coordination of the estate planning from Paul, Maria, and their team become vitally important because they work hand in hand together. So if a will's a note, we can have a whole workshop on trusts and get really complicated, but what I want you to envision a trust is a bucket. Why? What does a bucket do? A bucket first holds stuff. So the special needs trust is your bucket to hold whatever assets that you want to have used for your special needs dependent. What else does a bucket do? A bucket protects what's in it from outside sources. What we want to protect the assets for your special needs dependent from outside sources, things like the government, things like unscrupulous people, to make sure that they could always qualify for those benefits even though those resources are there for them. And the reason a special needs trust is so critically important is because a special needs trust is worded properly in that it doesn't pay for two specific things. Those specific things are food and shelter. The reason you cannot use trust funds to pay for food and shelter primarily is because that is what SSI is designed for. So if you have a trust that is not properly worded, that is not done by a qualified attorney, then what happens is you are now providing what is called in-kind support, which means that trust unfortunately would not qualify, and all of the efforts that you made wouldn't be worth it. So we want to make sure you understand a will is your note and a special needs trust is your bucket. So what we want to talk about when we do our planning is what we're going to put into that special needs trust. If you're doing your estate planning properly, you're meeting with Paul, Maria, and their team, you're crafting your will, you're setting up a proper special needs trust. Many times we meet with families, and when we ask them if they've done special needs planning and they've got a trust in place, the easy answer is, oh yeah, we've got that done. We have a special needs trust. But then the next question we ask is, okay, what are you going to put in the trust? And many times people hesitate. Oftentimes there's not really a coordinated answer if they've not done any advanced planning. And the result of that is typically two things that I want you to imagine. If you're saying, I have a special needs trust, and what I'm going to leave in it is, quote unquote, whatever's left, when you get into retirement, the older you get, there's only going to be primarily two things that will be left. One would be whatever's left in your retirement plans, and two would be your home. And while both of those things can be put in a special needs trust, they're probably two of the most inefficient things in terms of cost, in terms of tax, and in terms of liquidity. So what we teach our families is not only to have the wills and the trust in place, but we also guide them as to how they're going to fund that trust. What are they going to put into that trust? So step 9 is, in addition to your estate planning, to consider guardianship. Again, we can have a whole workshop on guardianship. The message here is very, very simple. 1, you need to make sure that you address it. Is there a need for guardianship? And 2, we want to make sure that everybody understands that guardianship is not an all or nothing thing. Every family is different. Every individual circumstance is different. But there are all different types of guardianships that are available. So let's suppose for a minute that you've attended the conference, you've attended several workshops, you've gotten great information, and you are now motivated to get your planning done. Not only are you getting your planning done, but you've had that meeting and we've decided, okay, who's going to be the care provider for my dependent with special needs when I'm no longer here? So if we've now identified that person, here's the next question. How do I assure the care that person would give is the kind of care that I would want them to have, the kind of care that you as a special needs parent or a guardian of a special needs dependent do day to day, almost subconsciously. It's called unconsciously competent. You do these things just by being there every day. Well, how do we now make sure that we allow the individual who's going to take over that role for us to have the best possible outcomes in that regard? And what we use in our firm and in our planning to coordinate all this together is called a letter of intent. Now, letters of intent can be all different forms. It can be a video. It can be a one-page note. We have a very extensive document to help you prepare a letter of intent. What we describe it as is it's like you giving a playbook to the person that's now going to be taking care of your special needs dependent on a day-to-day basis. And it addresses everything from their likes, their dislikes, what their medical needs are, what their social needs are, what you want for them in terms of housing, what you want for them in terms of social, things like religion, things like dating, things like marriage. And our document that we use to coordinate our planning is very comprehensive, for one specific reason, to make sure that you as a family don't miss anything. So some of our families are more medically involved than others, so we take that into account. Some of our families are going to have different levels of independence for their special needs dependent, and we want to take that into account. Now, the letter of intent is not a legal document, but it does work hand in hand with the estate planning documents to make sure that you have a successful outcome. So, we've gone through a lot of information in a short period of time. We've done it pretty quickly, but we want to get through two things that we want you to understand that are very important when you're talking about financial planning for a special needs dependent. That financial planning is going to go hand in hand with both legal and professional. So there are two sides to it. In years past, when I had the honor of speaking with Herb, and people would say, well, sounds like we need to see both of you. Who do we see first? And we always say, either one of us is absolutely fine. If you come to us, we're going to help you get set up with what you want to happen, where you are now, what strategies should you be implementing, and knowing who's going to be your trustee, who's going to be your guardian, and most importantly, how are you going to properly fund that trust? What are you going to put into that trust that's going to be able to provide a lifetime of care and a quality of life for your special needs dependent? And we want to do that for all of our families, regardless of your economic status. The greatest message that we could deliver to you today is, regardless of whatever level of economic status you come from, doing any planning has a significant impact, not only on your security, but on the life and security of your special needs dependent. So, let's talk a little bit about my organization and what we do to help families. My organization is called Special Needs Funding Coach. And if you see our website, it's called specialneedsfundingcoach.com. If you sign up in the chat for our spreadsheet, you'll see all of our information there as well, including my email, my phone number, etc. So what is it that we do? Number one, we're doing special needs financial planning to make sure that you make no mistakes. Number two, we want to make sure that what you want to happen, you now have a plan step by step and know that it's absolutely going to happen. We obviously work with special needs attorneys. Paul, Maria, and their team are amongst the best that we know in the state of New Jersey and the surrounding areas, and obviously you're here for that reason. And we have a wide variety of special needs trust funding options. So what does that mean? At the end of the day, a special needs trust could have as much money as you want in it, as much assets as you would like to have in it, and still your special needs dependent can qualify for government support services. So you could put anything you want in a trust. But as Paul mentioned earlier, I've been doing this a long time. And I will tell you quite frankly, there's only one thing that is the most efficient thing that you could put in a trust, and that is life insurance. We don't want you to leave your special needs dependent retirement plans. You shouldn't be leaving your special needs dependent a home, because the home has to be managed, the home has to be cared for, the home has to have taxes, etc. paid. There is no more cost or tax efficient way to fund a trust than with life insurance. There's all different kinds of life insurance. There's things that are called survivorship life, which allow you to take a small amount of money and make it a huge death benefit. One of the last cases we worked on, our family did $1 million of survivorship life. The total cost of that $1 million of survivorship life over a 20-year period is less than $150,000. So you're taking pennies and making them dollars at the exact time your special needs dependent needs it most. And when you're taking those dollars and they're tax-free dollars that are going into the special needs trust, that allows you to spend your own money for what you designed it for your retirement, for your quality of life, for the things that you want to do with and for your special needs dependent while you are here to do it. The whole role of our purpose is to make sure that you can do special needs planning without having to sacrifice your own retirement and other goals. Those things are possible by having a plan and having a process. Step 1, what do you want to happen? Step 2, where are you now? What do you have? Step 3, what can we do to suggest strategies that are going to help you accomplish number 1, what you want to happen? And then step 4 is implementing those things and managing them along the way. Now, if you haven't heard of this because it's relatively new in the industry, and I will tell you in my career, it is the biggest single advancement in life insurance that I have ever seen. It's called living benefits. If you've not heard of it or your life insurance does not have it, please pay attention because it's critical. Living benefits allows you as an individual with life insurance to collect against the death benefit without having to die. Living benefits allow you to collect against the death benefit if you have a chronic illness. If you needed long-term care, you can now collect against the death benefit of your life insurance tax-free to accomplish that. We know doing our special needs planning for a long time that special needs parents, guardians of special needs dependents, oftentimes are sacrificing their own health to care for their special needs dependent. And if you have a critical illness, a chronic illness that causes you to need long-term care, all of the planning that you put in place can now come crumbling down. So for those of you that are on the workshop, I'm going to ask you to take a note, and I'm going to ask you to go to YouTube. And I'm going to ask you to spend 3 minutes looking at a YouTube video that's called Living Benefits, the Smartphone of Life Insurance. It's a funny 3-minute cartoon that'll teach you all about what living benefits are. But for our special needs planning, it is a critical aspect of what we do for our families. So finally, at the end of our presentation, we want to have a message that comes across that you already have, and that by being on this workshop, we know you've received. Number 1, find quality professionals to assist you. All of the speakers, including the staff that Paul and Maria have provided during this workshop, are all experts and professionals in their field, all designed to bring you information and resources so you can have more positive outcomes for your planning, both for yourselves and your special needs dependent, particularly answering the question, what happens when I'm no longer here? Remember that you are the expert about your dependent. No one knows them better than you. And when you're talking about doing this planning, the 2 things we always want you to keep in mind are a lifetime of care and a quality of life for your special needs dependent. So if you look at the screen, there's our website, both my Special Needs Funding Coach website and my personal website. What we're also going to do is I'm going to go into the chat and again put in the smart sheet. If you want to sign up for a consultation, you can either go to our website, you can go to my website, you can call, email, whatever's best for you if you want a consultation. Anyone who attends one of our workshops, we do a free 20-minute consultation either by phone, video conference, Zoom, whatever you're comfortable with, so we can ask any questions that are specific to you that you may not want to ask in a public setting, and to see if going forward with planning would be advantageous for you. So I want to thank everybody. I know in New Jersey I can talk fast and get a lot of information out quickly, but right now what we'd like to do is we'd like to open it up for questions if anyone has any that we can address. Okay. If you see in the chat, you'll see
There you go.
Paul put it out through Maria. I put it out to everyone. There is a smart sheet. If you click on that smart sheet, that's where you'll be able to give us your contact information if you would like follow-up. For the time being.
So Don, thank you again for that. I've attended your presentation on a number of occasions. I've heard this a few times. I always walk away learning something new. So So thanks, and I've, it's not like I haven't been doing this for a long time either. So, it's always nice when you can learn something from another professional. One of the questions down in the chat box, probably the first one we got is, how do we get your slide deck, your slideshow, if you're able to share that?
What we'll do is we can send a 10-step summary. We have a document that we will send that addresses each of the 10 steps. We've sent that along to Christina. Christina can forward it along to anyone who is on the workshop and who requests that. And also, whether it's through the smart sheet or through my website, you can also contact us there. And that summary gives you a very good checklist that you can make notes on. I've done this. I need to address this. I need to expand on this. It's a good place to have everything in one spot. In addition to that, we provide what's called a special needs planning quiz, giving you questions to think about. Again, some of these things you may have started. Some of these things, thankfully, you've gotten checked off your checklist. Some of these things you may need to address. So the combination of that summary and that quiz will often help our families get started and formulate the plans and questions that they may have.
Right. Thanks, Don. And just so, right, Christina does have the 10-step planning thing, I believe, or we'll have it soon. Christina is our conference coordinator. She is also one of the non-lawyer professionals in our office. She'll be sending that stuff out to all. Yeah, she's the brains behind the whole damn thing. So the reality is that she'll be sending out those types of things to folks who have signed up for your workshop on Monday. We have begrudgingly given her tomorrow off. I'm not quite sure what we were thinking when we did that, but she'll send that stuff out on Monday. So some of the specific questions, Don, that have come up, someone asked, I think you touched upon this, should a house be put into a special needs trust? What are your thoughts on that? I mean, it can be, but,
Right. And this is oftentimes when I get to present with Paul or somebody from his team, or back in the days for Herb. That's a question that comes up a lot. Can you put a house in a trust? The legal answer is yes, but if you're going to put a house in a trust, there should be much more planning involved other than just saying, okay, I'm going to put my house in a trust because I want my special needs dependent to be able to live there. Remember, if you live in your home and you own your home, that home doesn't run itself. You have to pay for the upkeep of that home. You have to pay for the taxes in that home. You have to insure that home. So if you are now going to take a home and put it into a trust, the trust is going to have resources, provisions, and name an individual who is a trustee that will take care of all those things. So while you legally can put a home in a trust, it's oftentimes not the most efficient thing to do.
Or at least not the only thing to do. Yep. So, Don, you talked about beneficiary designations as part, the life insurances, the 401s, and all the rest of that stuff. Make sure you don't undermine your planning and all the rest of that good stuff, which is absolutely true. Person asked, what about stocks, securities? I don't think they have a beneficiary designation. So, what are your thoughts on that?
Here's what I would say. Again, it goes back to, you can put anything in a trust, but what is going to be the use of that asset while it's in the trust? And remember, what we're looking to do is we're looking to have resources in the trust that a trustee is going to be able to use to help your dependent with special needs. So if you're putting stocks into a trust, yes, you can. You can do it by your will saying that all of my assets now go into this trust. Now, from an estate planning perspective, if I'm leaving stocks to an individual directly, that's not a bad thing because they experience what's known as a step-up basis. Meaning, if I bought my Amazon stock at 10 and it's now at $2,000 and I leave that stock to an individual, they now get that stock at $2,000 and have to pay no tax on that gain. However, if we're talking about putting stocks in a special needs trust, how is that stock going to be able to benefit your special needs dependent without being sold? So most probably you'd be putting stocks in a trust, but you'd probably be liquidating those stocks to have cash to be able to spend for your special needs dependent. So again, Can you put stocks in a trust? Yes. It is the most efficient asset to put in the trust? Probably not.
And Don, if I could just piggyback on that a minute, just for purposes
Please.
of elaborating on the question a little bit. Again, the person said, what about stocks? And you're right. You're absolutely right. Everything you said is 100% correct. However, if the person really means a brokerage account or mutual fund or something like that, those things often do have beneficiary designations
They do.
associated. So you do want to be mindful. If it's a couple, if you have, as you said, you have a few shares of Amazon, a few shares of, Google, whatever it is, that's a different, the beneficiary designations or the lack thereof is a different question than my brokerage account.
Correct.
So be
Correct.
mindful of what you're really talking about.
Right. And to clarify, Paul, anything that you have that's retirement funds, whether it's
Yes.
401k, et cetera, they all have a named beneficiary. If they are non-qualified accounts, bank account, brokerage account, as Paul was referencing, there's something known as transfer on death, or TOD. You are allowed to use that transfer on death provision to name where those assets would go if they are non-qualified. But that also brings me back to the most efficient use of your assets. Again, I don't want to say this because I'm in the life insurance business, but I want you to think about it. There is no more tax or cost efficient way to fund a trust than with life insurance. So instead of taking my brokerage account or my IRA or 401k and saying, okay, I'll put that in the trust, why not use a percentage of that account to buy tax-free life insurance that would go in your trust, whether it's for you, your spouse, another individual, or survivorship. If there are ways to qualify for life insurance or there are annuities that have death benefits attached to them, they're typically the more efficient way to fund that trust.
Great. Thanks, Don. So when we're talking about inheritances, the question comes from somebody. We're talking about inheritances from grandparents or others giving assets to a special needs child is the nature of the question. And I'm going to add in there, as opposed to a special needs trust.
Correct.
What should grandparents do in those circumstances?
Yeah, and we were talking about it when we talked about beneficiaries and inheritances. We oftentimes talk about what we consider to be the well-intentioned relative or well-intentioned family friend who think it would be a nice idea to leave some resources to your special needs dependent, when in actuality, oftentimes it causes more problems because if those assets now go in that individual's name, again, if it's more than $2,000, now they're going to be removed from government support services. So I want you to picture something for a minute. And with proper planning, this should never happen, but Paul will tell you and will tell you it happens all too often. You have an individual with special needs who's an adult. They have a quality of life. They're living in a group home. They have a work program, etc., that they go to. Now either mom or dad or grandma and grandpa pass away and didn't do proper planning, and now that individual has assets in their name, which means they're immediately disqualified from government support services. So now when they've just lost a parent or a close relative, now their whole world's thrown upside down because they're removed from what they're familiar with and what their quality of life is. And as we mentioned earlier in the workshop, there's only two things that solve that, and it's time and money. And if you're not there to guide it, it makes it even more problematic.
Yeah, I mean, Don, I like the use of the well-intended relative. I always say that the well-intended relative will screw you every time because they will inadvertently make a mistake. You got to have a conversation with grandma and grandpa. Make sure they don't leave money to your kid with special needs directly.
Right. And
right.
let me add, both Paul's firm and our firm, when you do your proper planning and you set up a special needs trust, there's very nice notices and letters that you can send them to let them know that that trust exists. And if it is their intention to help your special needs dependent, to have those assets be noted to go directly into the trust and not to that individual.
Absolutely. Okay. The question comes up, and Don, I may just take this one because it's short. Then I'll let you. I'd like your thoughts on it. It says, how often should you review your special needs trust? and I'll tell you what I tell families: look at your documents every 3 to 5 years at a minimum, right, or at a maximum, I should say, and then you want to have them probably reviewed every 5 to 10 years. Just to take a look, professionally reviewed every 5 to 10 years. Don, I don't know if you have a different thought on that.
No, I would echo that same sentiment, because people ask us the same question. Well, what is the best time for us to do this type of planning? And what we always jokingly say is, what's the best time to plant a shade tree? It's 20 years ago.
Right.
Second best time is now. I will tell you definitively, from a financial perspective, the earlier you do your planning, the bigger impact small moves make. The later you wait, the more it takes to do that. Now, having said that, from a practical standpoint, we find that we're doing most of our planning, and Paul, you can tell me if you feel differently or the same, when special needs dependents are in the transition age, because families now start to realize the limitations of assets and Medicaid, et cetera, and realize that as an adult they need to do something. And sadly, the second biggest time is when our special needs parents are retiring and they recognize that they've not done any proper planning yet. Our message to you is very simple. Whatever level of economic status you are in, doing special needs planning has a significant impact on the quality of life of your special needs dependent after you're gone. And the earlier you do that planning, the better the outcomes and the results are going to be.
Absolutely. That is 100% true. And then the third time that we see, the most common time we see people begin their planning is when someone has received a scary diagnosis of something, or they're sick or whatever, and we definitely don't like to be engaging in planning under those circumstances. And Don, in your side of the, I always joke that Don deals with estate planning, with a warm hand, and I deal with it with a cold hand, right? So, but when because I'm really all talking about what happens after you cross over into the great beyond, right? So, but when you get scary diagnoses, or you get unfortunate news from a doctor or something, a lot of the planning options that Don can assist you with, they're off the table, because let's face it, it's harder to plan for financial eventualities, and it's hard to acquire instruments, like life insurance and so forth, when you have poor health. And my experience is every time my birthday has ended in a zero, my life insurance premiums, if I acquire new life insurance, it's more costly. So, do it when you're young. Get it done as quickly as you can, and make small moves down the road.
And what Paul is referencing is when somebody gets a bad diagnosis and they have to do all of this planning quickly, that's planning in crisis. And planning in crisis, while it can have an impact, will have nothing short of a shorter impact if you did that planning in advance.
Yeah. Yep. So, question comes up about, you were talking, Don, about benefits, SSI and Medicaid, and you talked about DI and so forth. And the person asks, if you're on SSD, is this still a problem if you also have Medicaid and health insurance as opposed to Medicare? So, I mean, I know the answer, Don. I don't know if you want to take a crack, if you have a thought.
I'm not sure. I'll let you answer it first, Paul. I'm not sure what the question is asking.
Well, I think the question really is like, look, my kid's on SSD as opposed to SSI, and so SSD is not a means-tested benefit. But if my kid's also on Medicare, do I still and Medicaid, I should say, as opposed to just being on Medicare and SSD, is there still an issue with that $2,000 resource limit? And the answer is absolutely yes. If you have a child with special needs that's on any means-tested government assistance benefit, and Medicaid is a means-tested government assistance benefit, you still got to be worried about those asset and resource limits, and you still got to worry about, spending money out of a trust in an improper way that could cause in-kind support and maintenance issues. Because, you'd be surprised how many means-tested government assistance benefits adults with special needs receive. And then you also have to be mindful of the fact that if your loved one is receiving services from the New Jersey Division of Developmental Disabilities, although DDD isn't a means-tested agency. They require you to be eligible for Medicaid if possible and stay eligible for Medicaid. So that $2,000 resource limit generally always applies.
Yeah, and Paul, let me circle back to the ABLE account for a minute.
Oh, good.
The
Yeah,
ABLE
go ahead.
account is the first tool that helps you mitigate those issues. Yes, we want our special needs dependent to be as independent as possible. Yes, we want them to be able to work, but we need those government support benefits for that to happen. So how do we handle that catch-22? The first thing is with an ABLE account. Not only can you put up to $15,000 a year in an ABLE account, but in the state of New Jersey, if you are working, the state of New Jersey allows you to put up to $27,140 into an ABLE account. So we didn't talk a lot on this workshop about that. One of the drawbacks of an ABLE account is if the special needs dependent or the special needs individual with the account passes away and there are assets in that account, then Medicaid gets the first pullback provision on those resources. What we teach our families is your special needs dependent should be able to work, should be able to be independent, and you should be using that ABLE account to allow them to do that. What you should not be doing is you should not be using the ABLE account as an accumulator and as a long-term vehicle for estate planning. The ABLE account is the first place you should be going to use resources for your special needs dependent. And as Paul will elaborate, the ABLE account allows you to even spend money on things like food and housing where a special needs trust does not. So in our planning, we teach our families that you should never worry about the clawback provision if you're handling the ABLE account properly, which is putting money in and taking money out. Because you can put money in, it grows tax-free. When you take it out to spend it on qualified expenses, you get to spend it tax-free. It's a valuable tool, but it's not the only tool.
That's absolutely right. And, I like to think of an ABLE account as sort of like a sidecar that comes along with, other comprehensive planning. It's not the main engine, it's not the main, ride, but it is really important to have. And it can be a very useful tool to have in your overall benefits and special needs planning. There's a great question was asked. I skipped a couple. I'm going to go down to a great question that was asked. Since you touched on ABLE and you touched on clawback provisions, great question was asked, what about payback provisions? And I don't know, Don, if you want to kind of touch or elaborate a little bit.
Let me touch on it quickly.
Third party, first party. Yeah, exactly.
Paul's much more qualified to tell you all about that, but it's very easy from our perspective. If you do a special needs trust and you do what's known as a third-party special needs trust, what that simply means is the assets that go in that trust were never in your special needs dependent's name. If you have a third-party special needs trust, you can have an infinite amount of money in that trust, and the government never gets it even after your special needs dependent passes away. You get to name where that money goes, whether it's other family members, whether it's charities, etc. A third-party special needs trust never has an issue with clawback provisions if it's written properly. What Paul will elaborate on is something called a first-party special needs trust, where those assets were in your special needs dependent's name.
Correct. So Don, 100% correct on the third-party special needs trust and the clawback provision or the lack thereof. There's another form of a special needs trust, like an ABLE account, the same kind of consequences. When the person with special needs passes away, anything left over in this first-party special needs trust has to go back to the government up to the amount that the government has spent on a person over the course of their lifetime. And that government callback agency is, generally speaking, is Medicaid, right? That's the agency that takes first when the person with special needs passes away. When do you use a first-party special needs trust as opposed to a third-party special needs trust? Well, you use it as little as possible. Like this is not your go-to type of trust, but these are the types of trusts that you use if you have no other choice, or if there was a circumstance that just arose that you have to clean up a little bit of a mess. So these things are commonly used when a grandparent dies and does leave a child money directly, particularly a lot of money directly to the child with special needs. We can clean up that clean up that problem by moving that money into a first-party special needs trust because it was an improperly received or improvidently received inheritance. If I've got a client who comes in and they say that, or a lawyer who calls me in a personal injury action who says, I'm settling a lawsuit from a medical malpractice case and my client is getting several $1,000,000 and, they are or will be on Medicaid someday, we set up a first-party special needs trust and we ask the court to park the proceeds of that settlement in a first-party special needs trust. If a client comes in and they said, my grandfather, my father set up or my mother set up a very large uniform gift to minors account and they've got a couple $100,000 in a UGMA account and the kid's about to turn 18, we got to apply for benefits and all the rest of that stuff. I'm going to park that money in a first-party special needs trust. And in all those circumstances, I'm going to say, don't go out on a wild hog spending spree, but don't be stingy with the spending of the trust either, because the only one who wins if you don't spend the money relatively aggressively is going to be the government. So you want to use that device as little as possible, and you always want to use a third-party trust if you can. So, and Don, your answer about the third-party trust is absolutely correct. So, all right, excellent. That was a very good question, and I like that. So another question is, I'm a 67-year-old single mom. I never had life insurance. Everything's in an IRA. Is it advisable for me to acquire life insurance now? And that may be a tough one to answer because there's a lot of variables.
Yeah, the easy answer would be yes, but there are a lot of circumstances on an individual basis that we would deal with. First of all, is that individual healthy enough to qualify for life insurance? Second of all, do they have the resources to pay for the life insurance? In the example that you just mentioned, Paul, if an individual has an IRA and they are able to use, let's say, 1% of that IRA each year to purchase life insurance that they could qualify for, that's a much more cost and tax efficient way to fund a trust than with the IRA. You have to remember, if you're working with a qualified attorney, Paul, Maria, and their team, your trust could have an IRA in it because it has an ultimate beneficiary. But remember the tax consequences of an IRA. Every dollar is taxable. There are required minimum distribution laws that are attached to those accounts. There's a lot less flexibility using an IRA than if you use other assets. And particularly with life insurance is the cleanest, most cost-efficient, and tax-efficient way to fund that trust. It also enables you as a parent, caregiver, guardian to do two things. Number one, to have the security of knowing exactly what amount is going to go into that trust if it's a life insurance policy. And two, it gives you the freedom, flexibility, and permission slip to spend more of your own assets while you're alive, not having to try to squirrel them away to leave something for the special needs dependent of the trust. So that sense of security will give you actually less stress in your life, and hopefully you can live a longer and more productive life and enjoy time with your special needs dependent.
I also think, Don, the question illustrates the point you were making before. It's easier, you have greater planning options in terms of insurance and other financial instruments, the sooner you start in life. And I don't want to make that person who asked that question feel bad. There's a whole lot of circumstances that may have arisen that prevented earlier planning. I know that the person says they're a single parent, so that in and of itself creates challenges as well. But I think, at least from my perspective, at least consulting with someone early on in your life and regularly continuing to consult with Don as time goes by is the best way to prevent planning in crisis, as you mentioned before. And Don, there's other instruments that folks can use later in life that are tax advantaged and have growth opportunities.
Absolutely.
So,
Life
insurance isn't the only answer.
Yeah. And again, you're absolutely right, Paul. We work with families lots and lots of times when they're doing this type of planning at their retirement. So it's never too late to do the planning. It still can have a significant impact. And again, it's never too late to purchase the life insurance as long as it's affordable, you can qualify for it, and we know exactly how to do it and where it fits.
Right. All right. So one question was, what was the name of that YouTube video again?
Yes. The YouTube video, it's called Living Benefits, the Smartphone of Life Insurance.
There you go.
It's 3 minutes long. It's in the form of a cartoon. It's entertaining and it's very educational. But again, it's something that many of our clients and most people haven't heard of. And in today's game, this is something that you should absolutely be considering. If you can have a life insurance policy that's going to help you while you're living, if you have cancer, if you have a heart attack, if you have a stroke, if you have a critical illness, if you need long-term care, if you have the ability to collect against that death benefit tax-free while you're living, it keeps all of your other planning in place, and it also helps mitigate all the blind spots that you might have when you're doing your retirement and special needs planning.
And I'm glad that it's in the form of a cartoon, because we're all adults here talking about very serious and heavy subjects, and you've told them to go watch Saturday morning cartoons again.
Saturday morning cartoons, what better?
Sort of like Schoolhouse Rock, but with a different purpose. So, all right. This is a unique question. I don't know if I don't know if I know the answer to this. Don, I mean, you can take a crack at it. What happens to the funds left over in HSA, health savings account, if funds remain upon the death of the parent? What issues does this present when the funds are moved into the estate or into a trust? No one's ever asked me that question, so I'm not.
It's an excellent question.
Yeah.
And a health savings account is a great vehicle for anyone to have, because if you don't use it for health care, then you are allowed to use it for supplemental retirement. So again, Paul, that's one of those things where if you have a health savings account and your intention is, when I pass away, whatever's left in that account is going to go into the trust, then there are better planning options for you. You can use the funds from those health savings accounts to supplement your own retirement and use other assets for the trust. You can use those funds in retirement to help you purchase life insurance and put that in the trust. If ultimately the health savings account is going to go into the trust, typically what's going to happen is all of the gain in that account is going to be taxed before the net money gets into the trust.
Mm-hmm. Yeah, because it was funded with pre-tax dollars.
Correct.
Yep. Mm-hmm. Question comes up. We were talking before, I guess, when the example, grandma, grandpa leave an inheritance directly to a child with special needs. Well-intended relatives have now created a mess, and now they're gone. The question comes up is, can an inheritance be refused by the recipient in order to preserve eligibility? I know the answer, Don. I don't know if you.
I'm going to leave that one to you.
All right. I don't want to No.
That's
right.
That's right.
It's in my alley, and it's a really good question, so I do want to address it. So the answer is no. You can't refuse an inheritance. You can, and the word you're looking for, the legal word you're using for, is disclaim. You cannot file a disclaimer if you are a person who's receiving government assistance benefits. Or I guess I should say you can. You can file the disclaimer. But if you disclaim an inheritance, so grandma dies and leaves your child with special needs, $50,000. You can say, I refuse it. I disclaim the money. But what will happen is Medicaid will then say, well, thank you very much. We'll take that now. All right. And I didn't make the rules and you didn't make the rules, but it's one of those bright line rules under the law that if you disclaim, they're going to just take it as if the special needs, person with special needs has passed away. So the better thing to do in those circumstances is park the money in the first, all things being equal, you park the money in the special needs trust, use it so as to hopefully defeat, the clawback provisions or the clawback rules that apply in those circumstances. So spend it now.
If I could make what I think is a very easy kind of priority list, if we're talking about spending assets, first place we would spend them is from the ABLE account. Second place would be the first party special needs trust. And then the end, of course, would be the third party special needs trust.
Yeah, because the third party, you're absolutely right. And the third party special needs trust is the only one that doesn't have a clawback provision. As Don said before, you can name anybody you want as the recipient of any leftover money. I mean, your neurotypically developing children, charitable entities. You can name Don and myself. We won't tell anybody. Don't worry about it. It'll be good. Our little
Secret safe with me.
Yeah, exactly. If you have a special needs trust, what is the best way to use an ABLE account? Are there good strategies to make routine deposits to the ABLE account, particularly if the individual receives a parent's Social Security disability benefits? So, Don, I don't know if you have any thoughts on that.
Certainly funding an ABLE account. Again, you can do it up to $15,000 a year. If that individual is working, you can put more money per year in it. We always teach our families that, and an ABLE account is an entire different conversation, where you get them, all those things, but there is one in the state of New Jersey. You can get any state you want. An individual can only have one. So what we want to teach our families, Paul, which makes most sense, is certainly you can fund the ABLE account, but it is also the first place you should be using to spend money for your special needs dependent. So it should not be a very large accumulator of assets. It should be an efficient way to use money to put in an account, to have that account grow tax-free while the money's in there, and to be able to spend those assets tax-free on things that you would need as qualified expenses. And if you look at the list of qualified expenses from an ABLE account, it's pretty hard to find something that's legal that wouldn't fit into that list.
That's right. That's right. Oftentimes, as well, if you have a circumstance where a person is paying rent or has housing assistance and they still have rent that they're going to supplement, or they don't have housing assistance and they need to pay rent. Rent is one of those things that can very easily be paid from an ABLE account. So lawyers do like their loopholes. So a lot of times what we advise families to do, if you have a special needs trust with a bunch of money in it, and you have an ABLE account, transfer $15,000 a year from the special needs trust to the ABLE account and use the ABLE account to pay rent, if that's what the circumstances of your child's life require, because it's a cleaner way to get rent paid if you pay it directly from an ABLE account. Now, are we spending special needs trust money on rent? Sure. But did the government create this little loophole? Sure. Do lawyers like loopholes? Absolutely. So that's what we're going to do. And I like to say, loopholes are fine as long as you use them for good and to avoid evil. So I think that's what we're doing here. So, there's a question, Don, you touched on this before, but I think it's worth repeating. Person says, hello, Paul. Hello back. Your firm handled my estate planning documents and special needs trust 12 years ago. So thanks for living another 12 years. Good job. And I need to go over them again, but I'm also interested in speaking to Don. Logistically, who should I talk to first? Right? You mentioned that before. So, maybe reiterate that again.
Yeah. And again, as long as you get to one of us, you'll get accomplished what you want. What Herb always used to say is go to Don because he has more free stuff first.
That sounds exactly like something Herb would say.
But what we would do is, and certainly if that trust is 12 years old, I'd be getting back with Paul to review it and update it. And what we've been doing with you is we would be helping you update what's going to go into the trust, how are you going to fund it, how are we going to properly position assets to do that, and also to make sure that you have your trustee updated and who your secondary trustee would be. So if you saw Paul first, you'd be updating that and then seeing us to categorize and figure out how to position assets. If you sat with my team first, we would be helping you figure out what the trust is going to get funded with, helping you make sure that you have a letter of intent to go along with the trust, and helping make sure that you have both trustees and successor trustees in line. So when you go to Paul to update, you're ready with that information.
Yeah. Yeah, to echo that, look, there's no wrong way or right way to do it. Yeah, just do it. I mean, the The wrong thing to do is to say, well, I'm not sure who to go see first, so I'm not going to go see anybody, right? That would be the wrong answer. A lot of times people see both at the same time, right? It's not that, hey, I talked to the bald guy and we've got a little bit of a plan over here. I talked to, the good looking guy and, we got a little bit of a plan over here. And then, we kind of talk. Yeah. Right. And then we talk to one another. We talk as a group.
Paul, you bring up a great point. And I'm sure, Paul, you've seen it in your practice. We've certainly seen it in ours, that oftentimes we see people in our workshops multiple times. And it's because you come back because you may have forgot something. You didn't get to it at this point, etc. So I'll echo Paul's words. The worst thing you can do is do nothing.
Right.
Doing something, seeing whether it's me first, Paul first, their team first, gets the ball rolling, and getting the professional advice from experienced people helps you realize things and do things that you hadn't thought of beforehand. Again, we do this because it's a passion of ours, because we want to bring you answers without you having to fight for them.
Yep. So there's another great question about the clawback that asked from the person who asked about the clawback before. Is there a limit on how much that can be clawed back by the government? Again, real good question. And the limit is the government cannot claw back more than what the government has actually spent. So in other words, let's say, by way of example, very quickly, that at the end of the person with special needs life, Medicaid has $1 million lien, right? They've spent $1 million on the person over the course of, his or her lifetime. And by the way, frankly, that's probably $1 million lien. That's probably a low number.
Right. I was going to say $1 million is very realistic.
It's actually probably a little artificially low, depending on things. Yeah. So the Medicaid has a governmental lien of $1 million. If there's $500,000 in the trust when the person with special needs passes away, Medicaid's getting that $500,000. That's it. The other $500,000, gets written off by the government, and that's the end of the line. If there's a $1 million Medicaid lien, but there's $2 million left in the trust when the individual passes away, Medicaid's going to take their $1 million. There's $1 million left over that are going to go to the estate of or to the heirs at law of the person with special needs, whoever they might be. Whether that's
Paul, let's just clarify what we're talking about here is a first-party special needs trust. If an individual does a third-party special needs trust, very important, everyone. Third-party special needs trust has no clawback provisions.
That's exactly right. Thank you for that clarification. Absolutely. There's a question. I only have time for a couple more. There's a question: what are the downsides of placing funds into a third-party special needs trust while the parents are still living?
If there is a downside, here's what it is. If you're putting assets into a third-party special needs trust while the parents are still living, you are certainly legally able to do that. The issue becomes a trust, just like an individual, has a tax ID number. So a trust has to file a tax return. The issue with funding a trust while you're living is if that trust is making money, if there are investments in the trust that are growing or they're earning interest, dividends, growth, etc., what happens is the special needs trust jumps to the highest tax bracket very, very quickly. So while you can fund a special needs trust while you're living, and there's nothing wrong with that, it's vitally important to manage the assets and the investments that you are putting in that trust. You can have a special needs trust own a life insurance policy. It doesn't have to, but if you're accumulating dollars in a life insurance policy, that life insurance policy is tax deferred. So even if that policy is in a trust, the trust won't have to pay tax on the growth of the assets. If you are funding a special needs trust with a specialized annuity, there are only certain companies that issue them, but annuities in a trust are tax deferred. If it's the proper annuity, monies can grow, and the trust still does not have to pay taxes until funds are dispersed.
The other downside there are good reasons to fund a special needs, third-party special needs trust when a parent is still alive. There are some, consequences to that, as Don explained, from a tax perspective. The other one is that from a practical perspective that I'll share is that once you take money out of your pocket and put it in the bucket, the special needs trust bucket, that's an irrevocable gift to the trust. You can't get it back, right? You can use it to spend for the benefit of the child with special needs, but you can't get it back to spend on yourself. So you need to make sure that you don't take money out of your own pocket and put it into a trust and then not be able to meet your own expenses and your own retirement plans and your own long-term care if that's what you eventually end up needing, and so forth. So just remember that these kinds of gifts to a trust like this, to a third-party trust, are irrevocable. Now, if you're blessed enough and fortunate enough to have what I like to call excess wealth, I'd like to be able to really understand what that means someday. But have excess wealth that you can fund a trust like that, that's great. But it's not something that generally is recommended for most average families. Just from my practical perspective.
And let me add on to that for a minute, Paul, because you're exactly right. When you put that money in trust, it's an irrevocable gift. What we're teaching families is if you have the life insurance policy, you make the trust beneficiary of that policy or partial beneficiary, depending on your estate planning needs. Now, what that enables you to do is enables you to accumulate monies in the life insurance policy on a tax-deferred basis. It enables you to use the assets in that life insurance policy to supplement your own retirement on a tax-free basis if you do it right. And lastly, with the living benefits, should you need long-term care, should you have the heart attack, stroke, cancer, etc., now you have access to tax-free dollars from the death benefit to help offset the financial hardship that comes along with those things.
Yep, absolutely. And with that, ladies and gentlemen, the clock on my desk tells me that we have run out of time. Don, that was great. 90 minutes of really great and valuable information. Guys, thank you very much for attending. Don, thank you very much, Special Needs Planning Coach. Thank you for being here.
Thank you for having me, Paul. I appreciate you being on. Everybody, thank you for sharing time with us. Hope you got something out of it. And please feel free to reach out for both of us if we can help you in any way.
All right, guys. Thanks, Don, again. Thanks, everybody, for attending. See you in the next workshop. Until then,
have a great day, everybody. Enjoy. Good luck, Paul.
Go watch Saturday morning cartoons. Thanks again, Don.
Thank you, Paul.
Thank you for watching this encore presentation from the Fall 2020 Hinkle, Pryor and Fisher Parent Empowerment Conference. With 24 other presentations to view, there is plenty of additional information to help you become empowered. As a reminder, the information contained in this video is not a substitute for individual legal advice and does not create an attorney-client relationship. Copyright 2020 Hinkle, Pryor and Fisher, PC, Attorneys at Law. All rights reserved.